Good day, my name is Mark Malore. I'm an attorney here in Riverside, California. I've got a number of clients in Indio that are facing some issues of bankruptcy during these hard economic times. So I thought it helpful to go over a few issues related to Chapter 7 and Chapter 13 bankruptcy to give you a quick little primer on some of the things you're looking at if you're thinking about filing for bankruptcy. The first thing to consider whether filing for Chapter 13 or Chapter 7 is do you pass the means test? And that's going to depend on whether your California median income is over the statutory amount or not. Depending on whether you're married or single, filing separately or jointly, you have to take a look at your household median income statutorily provided in California, and if it falls below the California statutory median income with deductions and exceptions, then you can file a Chapter 7 bankruptcy, which is good for another couple of reasons that I'll get into in a moment. Chapter 13, however, if your income is over the California median in range, then you're relegated to filing a Chapter 13. And why is that? What is the difference and why the distinction? Well, the difference is with a Chapter 13, in terms of time frame, the bankruptcy is concluded and debts are discharged within 90 to 120 days. And all your debt's discharged, so you don't have to pay anything back to any of the creditors. It's all discharged. With a Chapter 13, however, you're in a repayment program for 3 to 5 years, so the time frame is different, 3 to 5 years as opposed to 90 to 120 days. And secondarily, you have to repay a portion of that debt back to the creditors based on your income and the amount of debt you're carrying. There's a repayment portion, whether that's 10 cents on the dollar or 90 cents on the dollar. You have to repay a portion of that over the 3 to 5 year period. So those are some of the considerations to think about when filing Chapter 7 or Chapter 13 bankruptcy. Finally, I will bring up this point, and that is that if you're facing a house and you have a second on that house, and you've heard the term lien stripping, I want to give you some background on that so you don't fall into the circumstance that some of the clients that came into my office fell into. They filed a Chapter 7 bankruptcy and then came to my office after getting their discharge asking me, well, how do they lien strip the second from their home after filing a Chapter 7 bankruptcy? The quick answer to that is you can't. Because lien stripping is only available to you in a Chapter 13 bankruptcy. So if you're thinking about stripping the second from your home, and before you can think about that, you have to first determine whether the value of your home falls below the value of the first encumbering home. If so, then you are available for the lien stripping process to strip the second from your home. But you have to go through that 3 to 5 year repayment period and make the payments on your house during that period. And once you do, of course, then you can file a motion for lien stripping with the court, and the court will strip the second from your home, which will be an immediate injection of equity back into the home for you. Some homeowners in their particular financial circumstances find that assistance helpful, and that equity injection can make the difference in terms of bringing them current or at par with the value of the home as opposed to being underwater, especially here in the Inland Empire when we're about 50% underwater as a historical national average. So those are some of the issues you face in bankruptcy. I wanted to just go over those very briefly. If you have any personal questions or issues, concerns that you're dealing with, feel free to call my office, set up an appointment. We'd be happy to speak with you.